Is appointing a guardian ad litem a positive tool to help with child custody cases? It's a great question. I will respond to your question based upon my experience with guardians ad litem in Utah, where I practice divorce and family law. Each jurisdiction will have a different system governing the appointment, use, and powers of a guardian ad litem. So understand that in reading my response, that this applies only to Utah. In my professional opinion, rarely is a GAL a good idea. It's not worth the risk in my experience. There is too much of a chance of the GAL being more of a detriment than a benefit to anyone. What do I mean? Nobody and no thing is perfect, but as long as you meet certain minimal essential standards, you'll stay out of jail and stay employed. That's true for all of us. As long as institutions meet certain minimal essential standards, they will do and continue to do more good than harm. But there are many things that sound good in concept, yet just clearly don't work well in practice. The guardian ad litem, or GAL, is such a thing. So why do GAL programs still exist? Why are GALs appointed so frequently still in child custody cases? Two big reasons stand out in my mind. One, in my experience, courts like appointing GALs to relieve themselves of some of the fact-finding burdens. That's not an inherently bad idea if a GAL could be counted on to bear those fact-finding burdens competently, but they usually don't. And two, the idea of a child having his or her own attorney to stand in the child's shoes and give the child a voice sounds noble, perhaps even crucial to some. And I am sure that if one looked hard enough, one could find a GAL who accomplishes such noble objectives. In my experience, however, GALs are too afraid and/or apathetic to do their jobs well and are incentivized, or disincentivized as the case may be, by the legal system to do minimal, mediocre work yielding equivocal results that keep the GAL out of hot water. And that's the best I can say about GALs. Worst, most GALs are among the least competent attorneys and are often motivated by self-interest to recommend what they subjectively want done as opposed to where the evidence points. In my experience, the GALs don't perform with due diligence or provide insightful, impartial analysis generally. Instead, they base their ostensible findings and recommendations upon personal biases, agendas, and lazy but safe-sounding assumptions. I find many, not all, but many GALs to be extremely petty and judgmental. Be or do something irrelevant, but that the GAL disapproves of, like holding certain political, religious, or other views contrary to those of the GAL, and don't be surprised if the GAL's recommendations aren't in your favor, regardless of the actual factual and legal merits of your case. When a proposal is made to appoint a GAL, I generally oppose it. There are far better, far more reliable, less time-consuming, and less expensive ways to obtain accurate, useful information that a GAL is intended to produce, but rarely, if ever, does produce or produce very well. There is no need to appoint a third party to give a child a voice when the child can speak for himself or herself already. If the child is too young to talk or to testify competently, there is little that a GAL could provide of any substantive value anyway.